Wow, thank you. Hello, I'm Chris Smith. I'm a practicing barrister at Quadrant Chambers, and the question I'm addressing today is, what is litigation privilege? Now, this is an issue which lawyers have to deal with on a day-to-day basis. It's potentially quite a fun one, because it's one of the few occasions when you can suppress unhelpful information with a totally clean conscience. The usual scenario in which it arises is a client's presented you with a document, and the document's from a third party or one of its employees. And the document basically says words to the effect of, your claim is hopeless. Ow. Can you withhold it? Do you have to disclose it to the other side? Now, sometimes the boot could be on the other foot. I was involved in a case where we knew that the other side had instructed a surveyor, a Mr. Joe Bloggs, who'd gone in to look at the property in question. Now, when disclosure came around, there was no report from Joe Bloggs that was produced. So we thought, aha, we bet it's unhelpful. Can we force the other side to provide us with that document? The answer to these questions is, if the document is subject to litigation privilege, then no, it can't be produced. But if it's not privileged, then it has to be handed over. Before addressing the question of what is litigation privilege, I'm going to answer what is not litigation privilege. It's important to distinguish litigation privilege from its more awkward cousin, legal advice privilege. Legal advice privilege covers communications between a lawyer and his client for the purpose of obtaining or giving legal advice. Legal advice privilege can involve quite tricky questions as to who or what is the client. You may have heard of this series of horrendously difficult cases called Three Rivers. If so, I've got some good news for you. You don't need to grapple with them for the purpose of this talk. There's one paragraph that I'm going to refer you to, but otherwise push those to one side. All I'm going to say about legal advice privilege for today is two things. Firstly, it only covers communications between the lawyer and a client. So in that sense, it's narrower than litigation privilege. On the other hand, there doesn't have to be a tether to litigation. It can be in any context, and so in that sense, it's broader than litigation privilege. What's the test for litigation privilege? Well, this is, as foreshadowed, the one bit where we are going to go to Three Rivers, and we're going to go to the judgment of Lord Carlswell. This is regarded as the authoritative modern statement of the test for litigation privilege. Lord Carlswell firstly identifies the kinds of documents covered. He said, communications between parties and their solicitors and third parties for the purposes of obtaining information or advice in connection with existing or contemplated litigation. Documents of that sort are privileged, Lord Carlswell said, if they satisfy three conditions. 1, litigation must be in progress or contemplated. 2, the communications must have been for the sole or dominant purpose of conducting that litigation. And 3, the litigation must be adversarial, not investigative or inquisitorial. Let's break that down to the ingredients. Confidential, oral or written communications, which come into existence for the purpose of litigation which is in progress or contemplation, which are created for the purposes of obtaining information or advice, and which are created for the dominant purpose of conducting the litigation. So the first ingredient, litigation. What does litigation mean for these purposes? Well, it means adversarial proceedings. Court proceedings, arbitration proceedings, even internal disciplinary proceedings count. By contrast, purely fact-finding inquiries or investigations do not amount to litigation for the purposes of the privilege. Next requirement, the litigation must be in contemplation. Well, when is this satisfied? Litigation's been commenced. Tick. Litigation is likely. Again, tick. Litigation is a mere possibility. Cross. The court has said that if litigation is a mere possibility, the test isn't satisfied. But you don't need to establish that litigation is a likelihood. The courts have stressed there doesn't have to be a 50% chance or more of litigation for the privilege to be invoked. That deals with litigation. Next question. What kind of documents are covered? Firstly, for all the types of communications, they have to be confidential. That obviously follows. If the document in question has been splashed all over the front cover of the Daily Mail and is in the public domain, it can't be privileged. How can you withhold from evidence information that everyone's already aware of? Now, the individual categories of documents are these. Firstly, documents between the client and the lawyer. I mentioned earlier legal advice privilege, and there is an overlap here because documents of this nature may be covered by that privilege anyway. Next type of documents. Documents between the lawyers and a third party. Most commonly, this includes communications where the lawyers are asking potential witnesses or potential experts, can you help us, what do you think at this point, so on and so forth. These type of documents will be covered. The next category of documents are documents between a client and a third party. Now, this is a very important distinction from legal advice privilege. The lawyer does not need to be directly privy to the communications for them to be subject to the privilege. This provides protection to a category of documents that clients are quite often concerned about. We're sometimes told, I thought a former employee of mine, Mr. or Mrs. X, might be able to help with the litigation, and so we wrote to them asking for help. Thing is, I forgot, we sacked them for gross misconduct, and it turns out they're still kind of sore about that. And they wrote back, and they said lots of unhelpful things to our case. Do we have to disclose the letter in response? Well, no. So long as the other requirements for litigation privilege are satisfied, you don't have to disclose the document. The next requirement is these documents must be for the purpose of conducting litigation. Conducting litigation means obviously prosecuting or defending it, but it also means avoiding litigation or settling litigation. An important restriction is that the documents must seek advice or information for the purposes of the litigation. Documents containing a general chit-chat about the case don't constitute documents for the purposes of conducting litigation, and that's so even if the purpose of the document was to assist with settlement discussions. Finally, what if there are two purposes? Now, the purpose for conducting the litigation must be the dominant purpose. This can sometimes be tricky to apply in practice. The court's given some guidance. It said that this is a question of fact, and it says that the burden of establishing the dominant purpose lies on the party seeking to invoke the privilege. Some other words have been given to give the flavour of what's meant by dominant purpose. It's been said that the ruling purpose, the prevailing purpose, the paramount purpose, or the most influential purpose also captures what's required. So let's say there's a fire in my warehouse. The very next day I send in the surveyor. He reports back that I failed to put in the right batteries in my smoke detector. Oops. Can I withhold his report? I mean, I can say, after all, well, a fire always causes litigation. I might want to sue whatever's caused it. The people who own the property in my warehouse might want to sue me. Chances are, no. The dominant purpose test won't be satisfied here. Because at this stage, we're just trying to find out what's happened. That's your dominant purpose. And you can't equate wanting to know what has happened with a dominant purpose for use in litigation. By contrast, if I instruct the surveyor only after I've got a letter of claim from someone who's seeking to sue me, or let's say I receive such a letter of claim and I send in to my surveyor again to have another look. At that stage, it can be said that the dominant purpose of sending the surveyor in is for litigation which is in prospect. One other point I would make in this context is whose purpose matters. The author of the document or the person who's authorised its creation. Quite often either will do, but if there's a clash, it's the person who has directed the creation of the document whose purpose matters. So, conclusion. Can you claim litigation privilege? You need to ask if litigation is a mere possibility. Also, is the communication for the purposes of obtaining advice or information in conjunction with that litigation? If the advice is being sought for more than one purpose, what is the dominant purpose? Timing is quite often key here. If it's immediately after the incident or loss, then probably it's a pure fact-finding purpose. But if it's after the threat of litigation, then that is probably for the dominant purpose of litigation. If you can get through all those hoops, then you can withhold it, and that is litigation privilege.